Good afternoon, and thank you for joining us for our Martin Luther King recognition lunchtime presentation.
Monica, make yours quiet.
Oh, we're glad that you've joined us, and Liz will do the credits and the sponsorship at the end of today's presentation and the evaluations so that we can get right into today's presentation. I don't know how I ended up clicking this out. Today, we are very excited, though, that you're here and that we are presenting Tammy Walden. As you know, that this is Martin Luther King celebration period, and that there is a national and a global movement. The theme this year is shifting the culture climate through the study and practice of Kingian nonviolence. And we felt that Tammy's presentation, her work with the school response as the school response coordinator for Missouri Juvenile Justice Association, would be an excellent time to actually work with what we have already done in Kingian nonviolence. We know that although this is an annual celebration, MJJA does this work year-round, and you do it as juvenile professionals. We work through the racial and ethnic disparities, our RED, our restorative discipline, cognitive disabilities, de-escalation training, DEI training, school to prison pipeline. We're doing the King work and the mission year-round. So today, Tammy will share with you the importance of diversion in Missouri's juvenile courts. You know Tammy as the school response coordinator, the former chief of juvenile justice, the 26th Judicial Circuit, and we know her as someone who is certified court manager at the National Center for State Courts, Georgetown University Center for Juvenile Justice, one who continues to work as a member of the State Child Fatality Review Panel, the State Child Fatality Subcommittees on Child Abuse, Task Force on Child Safety, crossover. She is doing the work of King. So with that, we're going to stop and give it over to Tammy to talk about the importance of diversion in Missouri's juvenile courts. Tammy.
Good afternoon, everybody. Let me get my screen up here to share with you. I hope you're all sitting at your desk eating a sandwich.
I don't know what the heck happened.
Let's see.
We're up. Looks great.
Okay, well, let me make sure that my slides are going to go. They're not scrolling through, so hang on a minute. Let me try again. Y'all have to love technology, don't you? Okay, now let's see if I can get this sucker on full screen. It wasn't working too. Hey, there we go. Okay, yay! Thank you for the prayers, everybody. So, happy Martin Luther King Celebration Week. I'm happy to have been asked to do this presentation anytime, but especially during this special time. The presentation today, as you can tell by the slide, is going to be on the importance of using diversion in juvenile courts and why, even though the juvenile courts in Missouri, I must say, are pretty awesome and we do amazing work, we are not always the answer to every problem that's out there in the world. So generally speaking, I thought we probably better start with the definition of what is diversion anyway. Well, if you go to the dictionary, what the dictionary says is diversion is an act or an instance of diverting or straying off your normal course or your activity. It's basically a deviation from what you would normally do. Diversion isn't new in the juvenile justice system. It's a little newer in the more global justice system, when we think of the adult system has really sort of defined diversion as any kind of program that creates a process that would divert an offender from receiving a harsher punishment in the criminal justice system. It's not a specific program, it's not a specific idea, but it's usually like drug or alcohol counseling or rehabilitation or anger management, something that the offender could do to replace the behavior without receiving a criminal disposition at the end of his or her sentence. In juvenile justice, we have done, especially in Missouri, we have done a really good job defining exactly what diversion is. If you're not familiar yet, I haven't really taken a look at all of the names on the screen. So I don't really know, even if I did, I probably don't know many of you. How many of you are new to this profession or newer to this profession? But if you've been around for a hot second, you know that in 2017, the chief juvenile officers in 2014, the chief juvenile officers in the state of Missouri got together and created the juvenile officer performance standards that went into effect in 2017. Part of those standards include definitions, but really, we want to, in juvenile justice, diversion can be implemented or come in at any level. And I like to say that the Cliff Notes version of diversion is, we want to prevent whatever the next thing is from happening. Because as we'll see later in this presentation, there are oftentimes some unintended or unfortunate consequences or outcomes that are attached to whatever that next thing is. So here are some, I took this directly from the Juvenile Officer Performance Standards. So we actually have definitions in juvenile justice in Missouri about what diversion is. So level 1 diversion is a prevention program. And that means, again, it's not narrowly defined. So in your circuit, it might look different than it does in your neighbor's circuit. It might look different in a rural circuit as opposed to one of our metropolitan areas. So level 1 diversion program is defined as any community-based program designed and implemented to promote juvenile competency development or psychosocial functioning with a primary purpose of reducing the likelihood that the juvenile will reoffend and pick up another referral. Some definitions are preventative diversion programs by a juvenile shall not, I was on the other slide. The point that level 1 and I believe level 2 and 3 will also make, youth who are inserted into prevention programs as diversion should not ever be included in JIS. If you are not familiar in your circuit with how to do that, there's a method that OSCA developed years ago when we first started talking about diversion that would allow juvenile officers to continue to get workload credit, because obviously you're still working with those kids. You're not just saying, well, here, go to this program and best of luck to you, I'm closing your case. And, after a 10-minute phone call, you're working on that referral. You're meeting with the family, you're meeting with the provider, you're meeting with the child, you're tracking progress. You need to get workload credit for that. So when we first developed the diversion, what we found is if you're not entered in JIS, you're not getting workload credit. And if you don't know, you will in a couple seconds, that's how juvenile officer FTEs are allocated in the state, is by workload count. So OSCA came up with a plan that allows juvenile officers to still get credit for their work without to enter this kid in JIS, right? If you're not familiar with how it's done in your circuit, I encourage you to find out how it's done in your circuit. So level 2 diversion is, how do we divert youth from picking up a referral to the juvenile officer, right? So let's go back. Level 1 could be for any kid who is potentially going to be, who is at risk of a referral to the juvenile office, right? They don't have to have committed an offense already, because remember, we're classifying these as prevention programs. Level 2 diversion is any community-based program designed and implemented to provide diversion services to a juvenile wherein the alleged actions of the juvenile could result in a referral to the juvenile office. So there's already been some action on the part of the child that could result in a referral to the juvenile office. They're not just at risk, they've already committed an offense. They're not just at risk because of their circumstances, poor grades, disrespectful at home, those kind of things. Other factors that are brought to your attention. They've actually committed an offense that could result in a referral to the juvenile office. And the diversion program for level 2 would intend to aid the child in, number 1, accepting responsibility for their behavior, because that's important. Repair harm to the victim. Those of you who are familiar with the principles of restorative justice will know that this should sound familiar to you, right? Accept responsibility, accept consequences, repair harm, and promote competency and psychosocial functioning. Again, with the purpose of diverting the juvenile from picking up that referral to the juvenile officer. Level 2 cases, just like level 1 cases, shall not be entered into JIS, and there should be no consequence for any subsequent assessments or referrals. If a kid does pick up a referral later, and you do that history, you score on the JDTA or the risk assessment and the needs assessment, you score those prior referrals. If a child has been to diversion, those diversionary programs are not scored on those assessment instruments. So level 3 diversion, again, remember, we're talking about every step is, I'm trying to prevent whatever the next thing is. So we've talked about preventing the kid from ever coming to the attention of the juvenile office. We've talked about preventing the kid from picking up a referral to the juvenile office. Now we're talking about, how do we divert, you've got a referral, and how do we divert the child from formal court processing? I will tell you this right here is not new to juvenile justice. We've been doing this for 50 years, and this is not new. The theme of it has changed a bit. Informal adjustment conferences are diversions from formal court processing, right? But it doesn't have to be a traditional informal adjustment. Level 3 diversion, according to the performance standards, are any program designed and implemented to provide a juvenile the opportunity, again, this is kind of sound familiar, guys, repair harm to their victims, assume responsibility and consequences for their actions, and receive services to divert the juvenile from receiving formal court actions. In other words, nobody's going to file any pleadings. Our goal is to keep you out of that formal system where those documents aren't closed or gone forever in an office file, but they sort of linger on for life. So here we go. This is actually, the juvenile officer performance standards do not address additional diversion strategies, but one of the things I wanted this group to consider was, since we're talking about preventing the next thing, and the level 3 was preventing formal juvenile court intervention, I thought it might be a good idea that we talk about, think whether or not you guys should think of some strategies to divert a child from being certified to stand trial as an adult. So these are the statistics. Traditionally, Missouri has never certified that many children, and for that, we should all pat ourselves on the back. That's great. There are those youth who are referred to the juvenile court where the outcome is relatively clear about what needs to happen. However, what you're going to notice here is in 2020, there were only 31 youth in the entire state of Missouri. And remember, guys, we have St. Louis City, St. Louis County, Jackson County, Greene County. We have, I think, 12 single first-class counties. We've got some big metro areas in Missouri. So even including those metropolitan circuits, 31 kids in the entire state of Missouri were transferred to the adult criminal justice system in 2020. A slight increase in 2021, but look what happened when we took on 17-year-olds in July of 2021. In 2022, we more than doubled the number of youth who are certified in the state of Missouri. So I put this slide in here, definitely not as a condemnation for having raised the age. It was absolutely the right thing to do. We knew when we took on 17-year-olds that this was a likely outcome, but it's important to put this information out there so you'll know now it's time that we take a look at the results of having inserted 17-year-olds into our juvenile justice system, and are there steps we can take to reduce that number again. We don't have or somebody may have the numbers for 2023. I doubt it, since it's so early in the year. It's usually fall with the time the annual report comes out at OSCA. So I don't know what the numbers were for 2023. I certainly will be happy to share those with you if we get them. So level 4, there's actually a level 4 here, a diversion from commitment to DYS. So any program designed to divert a youth who we didn't divert them from formal court processing, right? They've been before the judge. The judge is going to make a determination, is going to make there's been an adjudication, and now we're going to have a disposition. What do we do to divert that youth from receiving a disposition that involves a commitment to the Division of Youth Services? And again, this is not narrowly defined. This can mean any program that you've come up in your circuit. It could be community-based. It can be a diversion program that's funded by the Division of Youth Services. They still have those funds that local courts can access to help divert, but it's to keep those kids in their own communities and avoid that commitment to DYS if possible. So why do we really want to talk about this at all? Why are we even talking about diversion? Well, because a number of studies have pointed to increasingly poor outcomes for children who are unnecessarily inserted into the juvenile justice system or unnecessarily receive services from the juvenile justice system. And broadly, they include a higher rate of recidivism, poor educational outcomes, barriers to employment when the child goes to seek a job, and actually insertion into the juvenile justice system increases a youth's chances of being inserted into the adult criminal justice system when they become an adult. And that is because this slide in particular, see the one in particular about poor educational outcomes. Hang on, I need to move my thing so I can see. There I go. Because a student who is arrested in high school is twice as likely to drop out of school as their peers. A student who appears in court during high school is 4 times as likely to drop out as their peers. And we all know, we all know that school connectedness is linked to lower rates of substance abuse, teen violence, suicide attempts, pregnancy, and mental health disorders. So if you're not familiar yet with some of the unintended consequences of how we process referrals or how we file if we want to take a youth on the formal side of the system. If you're not familiar yet with the Safe Schools Act, you need to become familiar with the Safe Schools Act and be aware that there are consequences when we file certain allegations and petitions that may impact a youth's ability to continue their education. We want to continue to keep our kids connected to not only to school for the education, but those pro-social activities that are connected with school. I will tell you that super early in my career, and we're talking like a long time ago, guys, like 1980. We didn't have a lot of training back in that day. So basically you were shown your desk and where to park and where the bathroom was and given a badge and said, go get them. So I sort of thought I would treat youth a lot like I had been raised, that if you misbehaved, that there would be a consequence for that misbehavior. One of the things I routinely did for the first probably 6 to 12 months of my career was, if a kid got in trouble and wound up on some type of supervision, one of my first inklings at the time, my inclinations, was to restrict their activities. And that often included extracurricular activities at school, or, because I was going to put the hammer down, and I was going to show them, and I was going to restrict their movements, and I was going to restrict their, their pro-social activities as a punishment. Well, it took me a minute before I figured out that I really was not helping by disconnecting them. I had a kid who was in trouble and hanging out with the wrong people. So what I was doing was severing those connections with everybody on the baseball team or the football team or the basketball team or youth group. Those are the kids I actually wanted them to be hanging around. So don't be dumb like me for a year. Think about how you restrict activities before you insert those things into your case management plans. Because again, school connectedness is linked to lots of greater outcomes for kids. Youth who are inserted into the juvenile justice system, even for relatively minor offenses, risk much more severe consequences for subsequent referrals, including being placed in juvenile detention. I think we've already touched on, when you score that JDTA, there's a place for how many prior offenses, how many, adjudicated referrals, or how many referrals were found true and put in this referral or put in this kid's case. We count, they get points for that, right? They score higher on the risk and needs assessment. We also want you to know that youth who are inserted into the juvenile justice system are at increased risk from being excluded for admission to college, for pursuing certain careers, or being unable to enlist in the military. And this is just so you think I didn't make this up. I didn't pull these stats out of the air or make them up. If you're interested, I'm happy to send you this document so you can go and look. I will tell you that this, I don't know if you can see this, Gary Sweeten, the second bullet point right here, is the one where I got the information about who will graduate. Disruption of high school education by arrest and court involvement. That's where that slide came from. But if you're interested, shoot me an email. I'm happy to share any of this information with you. So I don't know how many of you are familiar with OSCA's annual Juvenile and Family Court Division annual report, but this is where all of this information came from. And again, the stats are from 2022 because that's the most recent information that's been published. So in 2022, there were over 43,000 referrals sent to Missouri's 46 juvenile courts. 53% of those referrals originated from a law enforcement agency. That's higher than it's been over the last few years. 18% of all those referrals were sent from the Children's Division. That's lower than it's been over the past few years. 18% of all referrals were sent from school personnel or school resource officers. And I will tell you that we asked OSCA many years ago to separate out those agency ID codes. We wanted SROs separated from the traditional law enforcement, whether it's municipal or county or state or whatever. We wanted them separated out because we wanted to know how many of those referrals coming from law enforcement were coming from school-based law enforcement. So we could track and see whether the presence there was having an impact on school to prison pipeline. So that's why you see SROs not under law enforcement agency. We asked that that be separated. So all the rest of the referrals were sent by victims, relatives, parents, mental health providers, other juvenile courts. So that's sort of a breakdown of who sent the referrals. And here's an even further breakdown if you're interested. It's broken down by municipal police, children's division, school, the sheriff's office, SROs, juvenile court, other juvenile courts, parents, and you can see all that and break that down. And again, if you're not familiar with OSCA's annual report, you should be. So the other thing, and again, this referral, this data comes from the exact same document. 40% of referrals in 2022 were for delinquency. 29% of referrals were for child abuse, child neglect. 29% of referrals were for status. And 2% of referrals were for just administrative referrals. More like VC, like violation of valid court orders. 44% of all juvenile court referrals were received, law violation referrals were committed by youth who are 15 and 16 years old, which is interesting since our argument is going to be that we had a rise in certification due to the increased risk of inserting 17-year-olds into our system. So somebody way smarter than me in the area of data and data analysis is going to have to help me with this, but that's fascinated me. I sort of thought that number would be 16 and 17, but it's 15 and 16. So of those 44% of law violations committed by 15 and 16-year-olds, those youth were responsible for 53% of homicides, 54% of drug charges, 53% of liquor law violations, 52% of robberies, and 48% of stealing referrals. That's a busy group. Only referrals for threats, forgery, and municipal violations were committed at a higher rate, and those were committed by 13 and 14-year-olds, which isn't really surprising considering the maturity level is dropped a little bit, 13, 14. Here's where I really want you to start paying attention to ages. So I pulled some stats. Again, same report, 2022 Juvenile and Family Court Division Annual Report. Of all the referrals that were sent for assault in 2022, 66, assault, a criminal offense, were for children who are under the age of 10, elementary school children. 10-year-olds got 60 referrals for assault, 11-year-olds got 127, and 12-year-olds got 263. And you can read, I don't need to go through this whole thing, but the point I'm trying to make when you look at this graphic is, are you aware in your circuit? And that's why I'm going to encourage you to become best friends with your annual report and pay a lot of attention to your data. We have kids, 10 is probably, about 4th grade? So elementary students under 10, and it's not, I'm sorry, it's not broken down any further. When you get to under 10, everybody under 10 is grouped together. So I don't know how many of these kids were 9, 3rd graders. I don't know how many of them were 8, 2nd graders. I don't know because it's not broken down. They're all lumped together after that. The point I'm trying to make is you need to pay attention to the age of the kiddos who are referred and the allegation that's being contained in the referral and make a determination whether or not that's how you're going to proceed. So I just wanted to show you here because, we were so weirded out in 18, 19, 20, during COVID. What I really wanted you to see was just a comparison between referrals from 2020, 2021, And when we started to get a little bit normal in 2022, I wanted you to see the difference. Law violation referrals in 2020 were at 31%. They went up a smidge in 2021. They took a pretty significant jump, more than 20% in 2022. Status offenses, apparently those kids wreak havoc at a regular steady pace, no matter whether there's COVID or there's not COVID. We still got kids running away, not going to school, disobeying their parents. And you, quite honestly, I would have expected to see a little increase in status during COVID, because I think that those of you who were quarantined with your children might have seen an increase in some dysregular behavior. So, but you see status 20 to 22, no change, 29% of all of the total number of referrals. Child abuse, child neglect, 39% of referrals in 2020 contained allegations of child abuse or child neglect. In 21, we dropped a bit, about 10%, 8% to 36%. And then from between 2021 and 2022, we took a significant drop in the number of referrals that are received in your courts with allegations of child abuse or child neglect. And then administrative referrals, that's kind of remained the same. It's a rather insignificant number statistically. And again, those are going to be like VCO, violation of valid court order referrals, and those kind of things. So I'm going back to my pay attention to the age slide, because I want you to remember in 2020, there were a total of 1,424 criminal violations to the juvenile officer for children who are 12 and under. And I picked 12 because that's generally the age when children sort of transition out of elementary school into middle school, junior high, and go on. I just want you to be aware that statewide, and again, you can look your own circuit numbers up, your own county numbers up in this annual report. That's 1,400, well over 1,000 referrals for elementary age children for law violations in the state of Missouri. 160 of those referrals were for kids age 10, 344 for kids who are 11, 761 for those who are 12. 334 of those referrals contained allegations of felony for elementary age students. Misdemeanor, I also want, in particular, because of the timing of this presentation, I include this anyway, but I wanted to make sure that you saw this. Law violations by race. Misdemeanor was the most common charge among all race categories, right? White youth, Asian youth, Black youth. Misdemeanor is the most common type of referral. But as a percentage, felony referrals were higher for youth of color than they were for white youth. And here's how it's broken down. 46% of referrals on Native American youth were for felonies. 39% of referrals for Black youth were for felonies. 35% for Hispanic. 31% for Asian or Pacific Islander. 27% of law violation referrals for white youth were felonies. So I probably should have put this before I started, but if you are not familiar, again, I'll tout this for you. If you're not familiar with this report, you can access it. You guys can probably get it on CIC. I don't have access to CIC anymore since I retired from the court, but it's also available on OSCA's website. You just go type in Missouri Juvenile and Family Court Division Annual Report, and it pops up. You go to OSCA's website, and it will have every year with a link to every year's report. You're going to need this, especially if you're someone in your circuit who likes to talk about collecting data, or you want to be involved with decisions that affect policy, or you want to write a grant. You're going to need to know what are your numbers in your circuit. And there is all kinds of data in this report. If you're not familiar with it, make it your BFF, right? So what are we doing about all these elementary school kids that are being referred? What are we doing to encourage courts to divert kids? What are we doing about disproportionate referrals? So in 2021, MJJA received a grant from Missouri's Department of Public Safety to work on interrupting the school to prison pipeline. And the grant was broken down into 3 individual phases. Number 1, MJJA would hire a full-time school response coordinator to work with law enforcement, schools, and juvenile officers. That's me. The second phase was the school response coordinator, me, would work with schools and law enforcement to implement a trauma-informed strategy called Handle with Care in any interested school district, any interested law enforcement agency, anywhere in the state of Missouri for free. And the last phase is after we launch Handle with Care, then the school response coordinator's job becomes, we take on the additional responsibility of working with schools, law enforcement, juvenile officers to develop a continuum of responses to referrals that are made as a result of behavior at school. So we want to work with law enforcement, schools, juvenile officers to develop some alternatives to those referrals. And in my circuit, many years ago, we became the first circuit school district law enforcement agencies in the state to develop a school to prison pipeline response. We developed a memorandum of understanding that identified certain offenses where we all agreed if a student committed these, there were 5, we called them minor school-based offenses, no felonies, obviously, no crimes against people, kind of obviously. And we all agreed that if a youth committed one of these referral or one of these offenses at school, the school would not engage law enforcement, and law enforcement would not be involved. The school would not notify the juvenile officer, would not send a referral directly to the juvenile officer, but would instead enter this kid into a program whereby the behavior was addressed and the matter was addressed as a disciplinary issue as opposed to a juvenile justice referral detention kind of issue. So the school response coordinator, my job is to help educate schools, SROs, and juvenile officers on methods of interacting with youth in an effort to minimize the necessity of making that juvenile referral. So I already talked to you a little bit about the MOU that we used. I don't include a lot of information in this presentation about this because it's kind of in depth and it would have really just sort of overtaken the whole presentation. If you want to know more about that, my contact information is going to be at the end, and you're more than welcome to reach out to me at any time. So I also provide training and technical assistance to schools, to JOs, to law enforcement on recognizing and responding to trauma, and as well as how those partners can communicate better together and work on enhancing their relationships. So I don't know how many of you are familiar with Handle with Care, but Handle with Care, which is, this is the first phase of that 3-pronged approach that MJJA was using when they got their DPS grant in 2021. Handle with Care is a trauma-based, or a trauma-informed program that was developed not in Missouri, but in West Virginia in 2013. The sole purpose of developing Handle with Care was to notify schools when one of their students had been subjected to a potentially traumatic event. They were present, not necessarily involved, but we wanted that the folks in West Virginia wanted their schools to be able to know quickly so the people at school could respond differently to their students. So the premise is very simple with Handle with Care. First off, let me just confess to you, I worked 40 years in the 26th Circuit. I worked really closely with other juvenile officers around the state. I was on all kinds of statewide committees because I was too stupid to say no to people. And I had never, when Marcia Hazelhorse, our executive director, first approached me after I had retired and said, hey, I'm going to be putting out this job opening announcement. If you're interested, take a look. I said, okay. And I read it and I called her. I said, what is Handle with Care? And how do I not know about this? And it can't possibly be this simple. It is, and duh, I had never heard of it. So if you've never heard of it, don't feel bad. After 40 years, I hadn't either. In all fairness, it was only created in 2013, so I'll give myself some slack. The premise of Handle with Care is really simple. Law enforcement officers responding to any call where a school-aged child or a child who appears to be school age is present, whether or not that child was the direct victim of the trauma, whether that child was just a witness, whether they were present after, during some follow-up, that law enforcement officer is trained to make a notification to that child's school to let them know that they need to handle that student with care. So this is, and again, guys, I'm sorry. I think my slides may be a little out of order, but I want to make sure that you understand this goes on. This is specifically about Handle with Care. We train law enforcement officers how to start that conversation. So if there's a child present, how they engage someone there in a conversation so you can get enough information, and it's minimal information, that the officer knows the child's name, their date of birth, if they can get it, that's not particularly critical, and the name of the school where the child attends. So we have a statewide electronic notification system. So the officer, before clearing the scene, ideally before clearing the scene, goes online, sends that notification. So the notification arrives at the child's school before that child crosses through the front door the following school day. All the notice says is Johnny Smith, Dogwood Elementary, grade 2, Handle with Care. The school gets no details about the event that precipitated law enforcement having to come to the scene. You don't know if it was at the child's home, at the parking lot at Walmart, if it was a traffic accident, if it was a search warrant gone bad, if it was a suicide or a death in the home, if a parent got arrested in front of them. The school gets no details about the nature of the offense. They simply get a notice that says, hey, handle Johnny with care. So that way, anyone at the school, in particular, those teachers, and maybe it's the bus driver, those people at the school who interact with that student on a daily basis are aware that if they begin to notice a change in the student's behavior, or they become very dysregulated in class, and or they're agitated and they can't sit still, or maybe they pick up their desk and throw it across the room and they tell the teacher where he or she can stick that classroom textbook, that the school knows to respond and be prepared to respond differently if that child's behavior becomes dysregulated, because we know that child, we know through the Handle with Care notification that child has been subjected to an event that is potentially traumatic to them. If the teacher's interventions in the classroom don't appear to be positively affecting the child's behavior, the teacher can make a referral to the school counselor to assess whether there's any need for intervention on behalf of the school counselor. If the school counselor then does not feel that interventions that he or she is making are effective, the next step is for the school to engage the child and the family with community mental health agencies to address whatever it is that is affecting the child's behavior. So that's the Handle with Care model that was developed in West Virginia. In Missouri, what we are hoping, and again, we don't have enough data yet. We just rolled out Handle with Care in September 2021. We don't have enough data yet to effectively assess whether this is going to be effective. But what we're hoping is that by the schools receiving those early notifications and being prepped to respond with trauma-sensitive interventions, that there will be less reliance on engaging law enforcement, calling the SRO to the classroom to remove that first grader who just told you to where you could stick the textbook, or threw the desk across the room. And instead, what we hope is that those trauma-sensitive interventions regulate that behavior so it doesn't become necessary to engage law enforcement, because law enforcement's response often is out of caring for this child and wanting to get this child some help. Law enforcement's response is oftentimes then to send a referral for that child to the juvenile office so we can intervene. Well, sorry, I keep forgetting I'm retired. So you can intervene on behalf of that child. So one of the advantages to Handle with Care is that everything we do has been grant funded. We currently receive funding from Children's Justice Task Force. The grant that paid my salary has expired and will be reapplied for, but there's a gap in here. So we have amazing support from Children's Justice Task Force to continue to fund my position to work with schools and law enforcement agency. So there is no cost that's passed on for maintaining this electronic notification system. There's no cost that's passed on to agencies for my salaries. But one of the challenges will be of Handle with Care has been and will continue to be identifying those districts or those jurisdictions where services are lacking. And almost always where we find that is in rural areas where there is a significant shortage, like everything else, unfortunately, in some rural areas of qualified mental health providers who can help this child and their parents in addressing the behaviors. We can implement Handle with Care in an entire county. We can implement Handle with Care in one district. I will tell you that usually when I am doing a presentation, I encourage, although it's not my vote, I encourage districts to implement it county-wide. So when our law enforcement agencies are making those notifications, they don't have to sit and wonder, well, that school does Handle with Care, that school doesn't. I don't know about that one. We're making it too difficult for law enforcement if we do that. So I encourage every school district in a county to come on board at the same time. So how is Handle with Care diversion? I touched on that briefly, but I'll come back to it. As we know, because we talked about these numbers in earlier slides, we have 1,424 law violation referrals on elementary school age children in Missouri in 2022. So what we are proposing is, could we try a trauma-sensitive program to see if that doesn't have some impact on reducing those numbers? When a child exhibits escalating behaviors or dysregulated behavior in their classroom, what we want to encourage them to do is respond differently. Then there's an increased likelihood that if we do that, that law enforcement will not be called to assist in those situations. And if law enforcement isn't called to assist, then there's a decreased likelihood that that child will be inserted into the juvenile justice system as a result of that contact. So the second phase of interrupting the school to prison pipeline involves the school resource, the school response coordinator working with law enforcement agencies and juvenile officers, again, to create that continuum of responses to offenses that occur at school, on school property, at a school event. And what we're asking is that we start thinking about a referral to the juvenile officer as the intervention of last resort for those kind of offenses. So this might involve bringing law enforcement and schools and juvenile officers together to create an MOU, which would potentially identify minor school-based offenses for which all of those parties would have to agree that there would be no report made by law enforcement and no referral to the juvenile office. And instead, a very select minor group of offenses would be dealt with as disciplinary action at school and not insert that child into Missouri's juvenile justice system. It might also involve the juvenile officer working with the school to create alternatives to the referral. In my situation, that when we did ours, and again, we did our MOU in 2013, so it's been a hot minute since we did ours. We worked with the school to try to develop programs that the schools could use, since we were asking them to stop using law enforcement and referrals to the juvenile office. We went to them and said, what could we what could we give you in place of that referral? So we worked on that. One of the things we talked about was communication skill building, assistance with credit recovery, in-school counseling, linking students, this is going to sound familiar, linking students to clubs and activities that suit that skill set. Remember our slide on school connectedness and pro-social activities and the positive outcomes it have in keeping kids in school, reduction in suicide and pregnancies and mental health disorders. So that's something to think about as you engage your school in those conversations. So how this helps is if students are not reported to law enforcement and no juvenile referral is made, then they really truly are diverted from being inserted into the juvenile justice system while still being held accountable for their behavior. That's an important piece. We can't just cut that piece out when we're building those programs. Much like Handle with Care, we anticipate that similar success can be found when law enforcement, schools, and JOs come together to engage in conversation about roles and responsibilities and work together to create programs that we hope make their students successful. We want those students to stay in school. We want them to graduate. Again, go back and read Gary Sweeten's paper about consequences of not graduating from high school. Go anywhere on the web and look at the difference in the lifetime earnings that high school graduates have versus high school dropouts have. It's significant over the course of a lifetime. The amount of money that high school dropouts do not get. Both Handle with Care and all other components of MJJA's Title II work through our grant is heavy on using trauma-informed responses. We hope that by introducing trauma-informed responses and working with schools to implement trauma-informed responses, that it helps schools, respond differently to those students who misbehave or flat out break the law at school. I think those of you who've been around for a minute have seen a referral where there's no law violation, but there's a violation of school rules. And so we need to respectfully and collaboratively engage in a conversation where we help identify the difference between breaking a school rule, which doesn't need to involve the juvenile officer, and breaking a law, which might need to involve the juvenile officer. So I want to check my time real quick. We don't have very much time, so I might flip through some of these slides. I am more than happy to share my presentation with you, but there's my contact information. If any of you want to reach out to me, the easiest way is by email, and it's just tammy@mjja.org. That first number that you see there is our office number at MJJA in Jeff City, but I work remotely the vast majority of the time. So the second number is my cell phone. You're welcome to call me anytime, shoot me a text. I will tell you that if I get a call on my cell phone from a number I don't know, I have a tendency to let it go to voicemail. So shoot me a text, tell me who you are, but the best way is to check your email. So I'm going to stop sharing now because I think Liz needs to share a slide at the end. And obviously I'm happy to answer any questions.
Thanks, Tammy. Yes, we do have a few minutes. If anyone has any questions, feel free to unmute yourself and ask away.
And I'm going to mute myself so I can cough. Trust me, you did not want to hear that.
Hello, my name is Nakia Dawes. I'm with Jackson County Family Court. I do have a question. You mentioned diversion and the restorative justice practices, and you said victim a couple of times. And I wanted to see if there was anything out there that can address victims when we don't adjudicate. So our diversion program, our kids are not adjudicated. And so therefore, technically, they don't have a victim. But we do realize that there was harm done, maybe even to the community or to a particular person. So how do we make them whole without basically condemning or saying that this young person is the person who victimized you?
So, oops. So one of the things and yes, I have some information on that, and I'd be happy to send it to you if you don't mind shooting me an email so I can have your email address. I will tell you that in my previous life as a juvenile officer, we still notified victims even when we were not filing a formal pleading. We would notify victims even if all we were doing was an informal adjustment. And for those of you not particularly familiar with the precepts of restorative justice, it is very, Nakia makes a really valid point. It is very victim driven. It implies that harm is not done to the government necessarily. Harm is not done to the juvenile officer, to the juvenile office. Harm is done to an actual victim. Oftentimes the victim is the community, and that we should listen to the victim's concerns before making a disposition in our cases. And so, Nakia, I am happy to send you those sections in statute and the juvenile officer performance standards that talk about that. It may be, because you work in a very large court, it may be that you actually have SOP in your court that directs you how to do that, but I am more than happy to help you navigate that any way I can.
Tammy, this is Michelle Parks.
Hi, Michelle.
I just wanted to interject some additional information because we have the crime victims' rights in our office, and we look at that information and provide training in regards to it. So I know Jackson County does have some victim advocates there that you may be able to get that victim in touch with. I think it does depend on the case and so forth like that, but I would be happy to get you in touch with them. But I know that they have, from the prosecutor's office, they have a lot of different victim advocates in regards to that. But I did just want to let you know that in the statute 595.209, it does say for victims the right to be present at all criminal justice proceedings at which the defendant has such a right, including juvenile proceedings, where the offense would have been a felony if committed by an adult, even if the victim is called to testify or may be called to testify as a witness in the case. So I just wanted to provide some of that additional information. Of course, there is some, like Tammy was saying, with notifications and just keeping them aware of, you know, kind of what is going on in the case. And it does have that, you know, if the offense would be a felony if committed by an adult. So kind of keep that in mind, but you can definitely refer them to the victim advocates, I would think, in the prosecutor's office. Otherwise, there is some other agencies out there that we would be happy to provide resources in regards to. So you can always refer them to the Department of Public Safety, and I'll put my information in the chat box too.
Thank you, Michelle. I appreciate
Yes.
that. For those of you who didn't hear, Michelle works for the Department of Public Safety. And so in Missouri, we owe a big thank you to the Department of Public Safety. Without that grant funding from them, Handle with Care and School to Prison Pipeline, interrupting the schools to prison pipeline, and MJJ's involvement, that would never have happened because that funding was critical to get these programs off the ground. And so thank you to Michelle and Connie and everybody at DPS. And for those of you who don't know, go on DPS's website and look. They have an entire section in which Michelle is employed that deal with nothing but juvenile issues. If you haven't perused their website, you might want to do that.
Great. Thanks, Tammy. Well, that about does our time. The recording and slides will be available on stopRED.org probably about next week, along with any other past sessions. You can find the recordings and the presentations there, along with the blog that is written by Dr. Simmons. We'd love for you to get on there and interact with her. I did put a link for a short survey in the chat. Please take the time to do that. It is vital to our funding and improves our sessions. And speaking of funding, funds are made available for this project through the Missouri Department of Public Safety and the Missouri Juvenile Justice Advisory Group from funding provided by the U.S. Department of Justice, Office of Juvenile Justice and Delinquency Prevention. And I think the final note is that we do have our next session scheduled for February 21st. I believe it's going to be a panel that will speak on parents. It'll be parents of, is it youth of color, Dr. Simmons, that will share stories and insight with us next month. So look for that registration. So thank you so much, Tammy. You did a great job, and thank you all for being here.
Thank you, everybody. Stay safe and warm.